You now stand charged with another burglary of a motor vehicle.
This judge is not playing games. 2 burglary of motor vehicle charges in Texas. That's already enough to make a judge flip the "I've had enough" switch. And you're about to see exactly what that looks like.
So they now have you on 2 charges of burglary of motor vehicle. I'm telling you that I'm going to do everything in my power to protect my public. I don't care how old you are. I don't care how young you are. You go out there, you start acting a fool. It's not going to go well for you. Do you understand? I just set someone's bond now at nearly $30,000 because they're out there running amok. Don't do it. I'm going to test you 50 days from today. If I find that you continue to use, it's not going to go well for you. Do you understand? We need to do probable cause on the new B&B because we haven't done it. So do you mind? On the new case,
The failure to ID.
Quick legal breakdown. Finding the victim's key fob on the defendant? That's not circumstantial. That's a direct link. It's basically the courtroom equivalent of being caught holding the TV while saying, "I'm just borrowing it."
no. So there is a failure to ID. There's one BMV, and I guess later on in the day goes out and allegedly has another BMV.
Yes, Your Honor.
Okay.
On April 7th, 2025, law enforcement officers were dispatched to a burglary call in Harris County, Texas, and met with the complaining witness, who stated that around 6 a.m. he heard his car alarm going off and observed 2 males wearing all black making entry into his vehicle. Another law enforcement officer that was dispatched to that location observed 2 males matching the description in the same area, and the defendant had complaining witness's key fob on his person that was in the middle console of the vehicle. I believe when they broke it.
So that's how they put him, because he's got someone else's key fob.
Yes, Your Honor.
Okay.
Then he was identified by mobile AFIS.
She's putting an ankle monitor on a 16-year-old. Question for you all. Do you think strict monitoring like this helps prevent future crime, or just pushes teens deeper into the system? Let me know your take.
I think I need to get attached to that third one.
We'll attach you to it now. Yeah. So do you want to file I guess another one because he has a new case?
Your
The
Honor,
one in Fort 16?
Yeah. Or I guess we need to get it over here. You want to do a transfer? Okay. Yeah. You
that's
want
what I was going to say. On mine, it was still showing.
Yes. I don't want you out in the middle of the night. I'm going to put a monitor on your ankle so I know where you are at all times. I don't want you to have any contact with the complaining witnesses in this case, and I don't want you to go anywhere where they live. You pick up a 4th case, I'm going to go haywire. Do you understand? What are you doing with yourself these days?
No, I'm gonna finish school and I've been enjoying bed there.
Not while you have all these cases open. Did you not get enough sleep last night?
Not really.
While these cases are open, you must either have a job or get back into school full time. When you have too much time on your hands, you become self-destructive. And the days of you just sitting doing nothing are not going to happen. I'm bringing you back in 2 weeks, and I want to see what you have done to get a job. If you have done nothing, it's not going to go well for you. Do you understand?
This judge is giving a whole life intervention session right now. She's not just warning him. She's literally mapping out how these charges can destroy employment, financial aid, and military options. This is tough love in full attack mode.
That's not.
Do you have an ID? Okay, I want you to start going and applying for as many jobs as you can, or you get back into school. While these cases are open, military is not going to take you. I don't think. If that's something that you want to go do, that would be great, because that would give you great structure, which you probably really need. I mean, the military would be a fantastic idea for you. That would really, could potentially put you on a career path that could just lead you to the clouds, really. What you're doing now, you're charged with 2 counts of burglary. You know what that'll do to your career? Who hires burglars? No. You think you won't even get financial aid with that kind of stuff? Really, it will hose your whole career. So, for now, you must either get a full-time job, start looking into going back into school, but you doing nothing, it's not going to happen. Do you understand? All right, so what we'll do is we'll bring him back in 2 weeks. We'll see what he's done. I'm going to test you 50 days. don't use. And I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Yes, sir.
If I find that you're out past curfew, I will revoke all of your bonds. They're gonna go high. Okay, thanks. All right, take care, Mr. Bullock. Remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 4th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a sexual assault call and made contact with the complaining witness, who stated that her and the defendant.
Probable cause means a judge believes there's enough evidence to move the case forward. Not that he's guilty, but that the allegations are serious enough to proceed. And with details like this, yeah, this case was absolutely going forward.
Her stepfather were on their way home. The defendant began talking about the CW's boyfriend and then stated he wishes that she was his so he could, and this is quoting directly, Your Honor,
Say it.
taste her, fuck her, and that her innocence draws him towards her. Once inside the residence, the defendant came up from behind the complaining witness, wrapped his arms around her, and proceeded to kiss and lick the side of the complaining witness's neck. The complaining witness attempted to get away from the defendant, but the defendant restrained her until they fell to the floor, and the complaining witness was able to break free, run to her room, and lock the door. The complaining witness is 19 years old.
Mr. McQueen, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. I'm now issuing what's called a magistrate's order of emergency protection. This is a court order that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this court order, the state can and probably will file a violation of protective order, and that is the capital murder of misdemeanors. Don't pick up a violation of protective order.
Yes, sir.
You're ordered not to have any contact and not to be in possession of weapons. Okay. Okay, so now we need to talk about a bond. Guys, what say you?
Your Honor, due to the nature of the case and the defendant's criminal history, this stable request of the $5,000 bond be set.
What, was that 5,000, Judge? 5,000 is fine, Judge.
Okay, I'm gonna set your bond per agreement of the parties at $5,000. Do you have a bonding company here now?
We do.
Okay, I'll allow you to walk out with your bonding company. Do not pick up any new cases. Do not. He has 2 prior AFMs. One of them against the same complaining witness. Can you please let me know?
Yes, Your Honor, if I can just have a moment.
Yeah.
No, I know. He wants to make sure it's not.
I don't know if, I see
It's
2
not the-
AFMs.
not the
I'm
same
just not.
I don't believe it is the same person, Your Honor, from what I have,
It's my baby.
in this case.
Like 10 years ago.
It is not some complaining witness, Your Honor.
Okay, so we'll set your bond at like I said, at 5,000. Don't pick up any new cases. Don't do anything to violate the conditions of this bond. Otherwise, it's not going to go well for you. Do you understand?
Yes, sir.
All I want is my community safe, and I'm going to do everything in my power to protect it. So we'll have you now, since reset or no?
Are they posting their own bond?
Yeah,
And we don't.
yeah, we're not going to do a reset at this time because what'll happen is he'll get a 7-day, we can't essentially. So once he goes post bond, you will get a 7-day setting. Just reach out to Victoria, email, and then we can give you a further date so you just don't have to come back in a week.
Thank you, Judge.
We'll have him sign all his conditions. Now, do not leave until you sign your conditions, and after that, we'll let you go. And then we'll let him go with the bonding company.
Thank you.
Yeah. Okay. Thanks, guys.
This is the part where the judge goes full PSA. And honestly, she's right. Once you have a DWI on your record, every traffic stop becomes a gamble. Question for the comments. Should repeat DWI offenders get harsher automatic penalties?
Both of you have breaths over 0.15. That makes it now a Class A misdemeanor. You are facing a year in jail and or a $4,000 fine. Both of you have negotiated plea bargain agreements for essentially slaps on the wrist. After today, each of you will be facing 90 days in jail. for any other DWIs that you pick up. And I will tell you now, if you're ever in a car, you get pulled over, first thing officers do is they look at your record. If they see that you have prior DWIs and they go up to your window and they smell alcohol or dope, it's probably not going to go well for either of you. So if I were you, I would never get into a car and drive, even if you've had a sip of alcohol, because you're taking a huge risk, especially if you're not in this country with permission. Do each of you understand?
Yes, sir.
Minimum of 90 days in jail from now on. No more slaps on the wrist. Both of you give up a lot of rights by entering into these agreements. You're pleading guilty to these charges. They will go on your record. They will be there forever. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. Both of you give up the right to appeal as well, meaning that once you plead guilty, there's no changing. Do each of you understand?
Yes, sir.
Is this what you want to do?
Can I say? Yes, sir. Yes, sir.
How do you, each of you plead to the offense of driving while intoxicated?
Guilty, sir. Guilty,
I
sir.
want you to understand that everybody makes mistakes. When you continue to make mistakes, when you endanger other people's lives, that's when we really come down hard on you. There is a $4,500 surcharge that would normally apply with these types of cases. I understand that mistakes happen, and I will take it off of you now. But if you make another mistake and you pick up another DWI, a second DWI, it's a surcharge of $6,000. And if you don't pay it, every $100 you owe, you sit 1 day in jail. Not to mention the minimum 90-day sentence that there is. So get a clue. If you want to drink 32 beers, 52 shots of tequila, take an Uber or find another way to get around. Do you understand? I'm going to suspend both of your ability to drive for 90 days. Do not drive. Otherwise, you will be back here. Mr. Chirinos, I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you have done. Mr. Hernandez, I'm going to sentence you to 3 days in jail. I will give you credit for the 1 day that you have done. Good luck to you, gentlemen. Thank you, guys. Okay. Mr. Pullard, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 7th, 2025, in Harris County, Texas, officers a theft shoplifting call and an off-duty officer who had detained the defendant and a co-defendant. The off-duty officer was informed by mall security that the co-defendant had stolen merchandise from Zoomies and passed all points of sale and ran out of the store. The co-defendant then ran to a car in the parking lot where the defendant and another individual were located. He blocked in the vehicle and were able to detain the defendant and the co-defendant. Officers found a handgun in the glove compartment of the vehicle. Didn't say the handgun belonged to him. And the officers observed the strong odor of marijuana.
The officers what?
Observed the strong odor of marijuana.
Okay.
The defendant did state he had weed or marijuana in his pocket. The officers retrieved a bag of a leafy green substance from the defendant's pocket.
So he's a passenger though, right? Or was he the driver?
I believe he was the driver. Let me make sure that's correct, Your Honor. He was in the driver's seat. That's correct.
Mr. Pullard, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license, please?
Yes, Your Honor.
What do you do in life these days, sir?
I just finished electrician school out in Port Arthur. I just recently moved back to Houston.
Did you get your license or no?
Only thing I have from the school was like an OSHA 10 certification, but and basic training of electrician, but it's more classes I have to take to
Get
get
on it, doggone it. What are you waiting for? You know?
It's just